Hey guys, reading some of the comments on the SLAPP order, I wanted to go back over a couple of points, maybe clarify those just from having scanned over the order last night and explain a few things. So this SLAPP motion to strike, which is a strategic lawsuit against public participation. So it's designed to protect people from lawsuits that, rich people might bring to shut somebody up for saying something. That's the idea behind it. Anyway, it's a two-pronged motion. And the first is you have to show that the speech that you did, whatever you said or whatever, comes under the statute. In other words, it's a thing that could be protected by the statute. That's just one thing that has to happen. But if you do that, then it moves over to the person who brought the lawsuit to satisfy prong two, which is they have to show that, okay, because it's not an immunity. If it's some kind of speech, doesn't mean you can't be sued for it. That what happens then is the plaintiff has to show some evidence to the court that the court could go, yeah, if that's true, you could potentially win this case. The court doesn't weigh the evidence. It's not a trial. They don't say, well, everybody give me everything you got and I'll read your stuff and I'll see who I decide to believe. That's not what happens in a motion like this. Instead, what Manson proposes or any plaintiff proposes is essentially, for the most part, taken to be true or in the light most favorable anyway to Manson to say, well, if you have this evidence and it were to be proven at trial, you could win this case. But if you don't, then the cause of action based on this protected speech would be struck. So it has to be protected speech. And then you have to show that there's no evidence, if you're a defendant and you want this struck, that would sustain a verdict. So let's look at that, particularly on the FBI letter, because that's a big deal, right? So the first thing that happens is Manson alleges in a lawsuit that Wood filed this FBI letter as part of a custody proceeding. And everybody knows that by now, right? Well, Wood argues in her motion to strike that, well, look, what I do in a litigation proceeding is protected as part of this anti-slapp situation. And by protected, I don't mean immune. I do not mean it's immunity. I mean that it can be tested in this motion to see whether it's support a cause of action or not. And she cites Civil Procedure Section 425.16, Subdivision E, that says, an act in furtherance of a person's right of petition or free speech under the United States or California Constitution in connection with any written or oral statement or writing made before a legislative, executive, or judicial proceeding. Okay? So judicial proceeding. So under the plain language of that statute, as well as case law that interprets it, if somebody communicates something in court, that's going to come under the anti-slapp statute. So in other words, prong one would be satisfied and you have to go to prong two. It's not the end of the argument. And as a matter of fact, Manson says, well, wait a minute. This was a forged letter. This was illegal. So you should remove this litigation privilege. You should take it outside of the anti-slapp protection because it was illegal. Okay. So you can't let the person benefit from their illegal activity. And if Manson succeeded in that and the judge said, well, it doesn't even get prong one. It's not the kind of speech that's covered or for a disqualifying reason like illegality, it's taken out of prong one, then the letter would not be struck. Manson wouldn't have to go any further with this to show evidence or whatever. But the court looked at the case law in California, which is kind of interesting, and I will find it and quote it to you. So before citing this case, I want to point out that all that was alleged in the lawsuit, or really shown by the evidence, is that this letter made its way into a court file in a proceeding and not that it was handed out to people, because that would have changed the equation. So he really needs to fight against this litigation privilege. So the parties cite Flatley versus Moreau, 2006, where the California Supreme Court says in a motion to strike, this anti-slapp type of motion, that if the defendant's exercise of protected speech or petition rights is illegal, then it can be precluded from being used to invoke the anti-slapp statute. But it says that it has to be illegal as a matter of law. Now, that doesn't mean that if you do this, that's illegal. That's what they're saying is the facts showing it's illegal have to be there as a matter of law. And basically, as a matter of law means it has to be established. And here they say it more plainly. In reaching this conclusion, we emphasize the question of whether the defendant's underlying conduct was illegal as a matter of law is preliminary. It's unrelated to the second prong, right? That's different. We already said that, so we're ahead of the Supreme Court there about the probability of prevailing. So anyway, the showing required to establish conduct that is illegal as a matter of law must be done through defendant's concession. So the defendant says, yeah, that was illegal, and we know Wood didn't agree that she did something illegal, or by uncontroverted and conclusive evidence. And so that's why you get this, it's not uncontroverted, because Wood said, I didn't forge this letter. I mean, she said it in more words than that. So that's basically what she said. Now, Manson certainly had some evidence that could cause you to think that wasn't true, right? I mean, a lot of people believe she did make it, but she controverted that by saying I didn't. And there certainly is a scenario where she didn't, whether you believe it or not. So the point is here, what the Supreme Court has said, at least as this judge is interpreting it, is if the sides have a dispute over the illegality, then the activity stays inside of prong one. That if you want it to be the protection to be removed for illegality, that has to either be conceded by the defendant or there's just no evidence to controvert it at all. And here there is some evidence to controvert it. So that means Manson can't win on prong one. It doesn't mean that the letter gets struck. It just goes to prong two, which is, does this letter support Manson's claims and show a probability that he could succeed based on this letter? And that, I think, is really where the judge's heartburn was, is that, hey, how does this letter connect to the case? So again, the trial court here goes up to higher level courts to see what the guidance is. And they found another case in the Kinney court where they said that the conduct that the plaintiff there was complaining about involved communications that were made during the course of and directly related to judicial proceedings and nothing else. And that's what the judge had kind of telegraphed to Manson's team earlier in this case during the discovery phase is, you know, if you want me to connect this to your case outside of the judicial proceeding where it was filed in a custody case, show me where this letter was used in this recruiting. And certainly in the comments here and on various social media platforms, people have said, oh my God, they used this letter. It was posted everywhere, etc. But where is that presented by the plaintiff in this case in the record for the court to see it? And I didn't see that. So that's why the court made the decision that was made, that she made, which is it is a kind of speech in front of a judicial proceeding. It is controverted whether she engaged in illegal conduct or not. You can believe that she did. I totally understand that. That's separate from the legal standard of trying to get it out from under the prong one. But prong two is really where all the action is, which is, did the plaintiff manage to show that this letter was used in this campaign of alleged recruiting and pressuring and telling people to lie and stuff like that? And the court said that there's not the evidence of that here on this record. So that's why the FBI letter was struck. Because I've seen some comments like, I guess you just can do anything illegal that you want to do. Courts don't care about whether you do anything illegal or not. And that's not obviously what this decision is here. What the judge said is, you have a civil claim for money, okay, in this case. And if it's going to be based on this letter, then show me how this letter was used to do what you said was wrong, which was pressuring people to lie and recruiting people. Just show me the connection. And if you can't do that, you can't use it to go after money against these people, because that's what this is for. For example, in the case where the letter was filed, if it's as bad as people think it is, the judge there can do something about it, right? I mean, that's where it was filed, right? So if it is as wrong as people, as many people perceive it to be, the court there could handle it. There's another party on the other side of that case. It's a custody proceeding. That's an aggrieved person on that side. That would be a person with a motive to bring this up to that court if it were an issue there. So I'm not making any judgments or even know what's currently going on in those cases. But my point is, the judge's decision here that this letter really doesn't connect to this lawsuit has nothing to do with controlling a court where the letter was actually used. Also, it has nothing to do with people like, I guess you could just impersonate law enforcement personnel, stuff like that. This ruling has nothing to do with any of that, okay? It absolutely doesn't have anything to do with that. If a law enforcement agency has heartburn over this letter and wants to do something about it, this ruling has nothing to do with any of that. So it's not a statement on a criminal activity in the United States. It is saying, show me how this letter was used in this case. And the judge didn't feel like that happened. So I think, if Manson wants to appeal on this specific point, he's going to have to defeat that logic by the judge on this prong two, or the standard would have to be changed for prong one so that he could have won there. Anyway, it looks to me like this was in accord with the law. Even though a different judge could have reached a different decision, you should be able to at least see the logic here, which is this was something put forward in a judicial proceeding, so it comes under the anti-slapp statute. There is a dispute about whether it was illegal or not, so it doesn't get thrown out of the anti-slapp statute. So that moves it to prong two, which is show me what it has to do with this case and how it would lead to sustaining a verdict. I mean, you can't just say it's bad, it's wrong, it's credibility buster, and it's terrible and illegal. Even if all those things are true, you still got to connect it to the case, right? You have to show it. Like if Evan Rachel Wood had rear-ended my car and I wanted to sue her over it, and I bring this FBI letter up, the judge is going to say, what has that got to do with her rear-ending your car? Now, that's a little bit of an extreme example, but the point would be maybe I'd say, well, she was reading it while she ran into my car, and then maybe it would be relevant. And all Manson had to do here, I think, to bring this relevance together would be to have had somebody testify or give them a declaration or something where they said, this FBI letter was shown to me or given to me and proof, of what was going on with Manson, and it was used to cajole me into participating in this scheme against him. He needed something like that to tie the letter into it. So that's the story on what happened with the FBI letter and maybe a little bit more explanation of what that's about. That's it. Thanks, bye.